Good morning, my lords. Yesterday, just before you rose, I think you were handed Metcalfe and Mardell. I don't know if all your lordships have had an opportunity to look through it, but if I can summarise it very briefly, so far as is relevant to this case, there was an allegation of fraud made in a case. The case failed, and a wasted costs order was made or raised by the successful party, saying that counsel on the other side had wasted costs in alleging fraud, that they were not entitled to do so because the threshold for pleading fraud required credible, admissible evidence which would raise a prima facie case of fraud. And before that stage is reached, no allegation of fraud should have been made. In the Court of Appeal, a majority of their lordships upheld that claim. That was reversed in the House of Lords unanimously on the basis that the true test requires credible evidence that raises a prima facie case of fraud, but the evidence itself does not have to be admissible as a matter of law in a court of law. That is said by all five of their lordships. If it would help your lordships, if I just take you to the passages where that is said. And the reason I'm referring you to this case is that this was the case which counsel referred to in Sefton, saying that that is the test. If one looks at the head note, just above letter E, towards the right-hand column, the claimant applied pursuant to Section 51 of the Supreme Court Act 1981 for a wasted costs order against the defendant's counsel on the ground that they had acted in contravention of para 606 of the Code of Conduct of the Bar of England and Wales, in that they could not have had before them reasonable, credible material which established a prima facie case of fraud. And if one turns over para 2, that paragraph 606C of the Code of Conduct of the Bar did not require that counsel should, when making allegations of fraud in pleadings and other documents, have before him reasonably credible material in the form of evidence. This was the defence, in the form of evidence which was admissible in court to support the allegations, but that at the preparatory stage it was sufficient if the material before counsel was of such a character as to lead responsible counsel exercising an objective professional judgment to conclude that serious allegations could properly be based upon it. 3, allowing the appeal that since wasted costs orders had a penal effect upon counsel against whom they were made, counsel were entitled to defend themselves against the making of the orders by placing before the court without restriction all material which was relevant to the issue as to whether they had before them at the time of settling the impugned documents reasonably credible material which established a prima facie case of fraud. So if one turns to page 125, I don't know if there is an electronic version of this. Lord Bingham begins his judgment there, and paragraph 10 of that, which is at page 128, paragraph 10 between letters C and D on 128. Before that application was resolved, Mr. Metcalfe compromised the action against Mr. Mardell, Mr. Kemp, and the TMO. The terms of the compromise are not material, save to note that it expressly preserved and excluded Mr. Metcalfe's claim for wasted costs against the barristers. The principal basis upon which counsel for Mr. Metcalfe advanced the application for wasted costs against the barristers was that it had been improper of them as counsel for the defendants to have advanced allegations of fraud and other improprieties in the draft amended notice of appeal, in the supplementary skeleton argument and at the hearing of the appeal, when in contravention of paragraph 606 of the Code of Conduct of the Bar of England and Wales, they could not have had before them reasonably credible material establishing a prima facie case of fraud. Mr. Metcalfe sought to recover as wasted costs the costs said to have been incurred in investigating and rebutting the allegations made, both by way of written evidence and oral argument at the hearing. And then para 11 sets out paragraph 606, and you'll see just level with letter G, and has before him reasonable, credible material which, as it stands, establishes a prima facie case of fraud. And then if we turn to paras 21 and 22 on page 134, we'll see what his lordship says about that. Construction of paragraph 606 of the Code of Conduct. As is evident from the quotations and the judgments of the majority and the minority of the Court of Appeal set out in paras 16 and 17 above, there was a difference of opinion on the interpretation of paragraph 606. The majority held that when putting his signature to an allegation of fraud or dishonesty, counsel must have before him evidence in a form to be put before the court to make good the allegation. Mr. Justice Wilson held that counsel must have material, but it need not be evidence in admissible form. And then one just drops down to 3 lines above letter E on the right-hand margin. As the rule recognises, counsel could not properly judge it proper to make such an allegation unless he had material before him which he judged to be reasonably credible and which appeared to justify the allegation. There's a double use of the word properly, which is quite felicitous in this case because properly is the expression used in Sefton. And then one drops down to letter F in the left-hand column. I would, however, agree with Mr. Justice Wilson that at the preparatory stage, the requirement is not that counsel should necessarily have before him evidence in admissible form, but that he should have material of such a character as to lead responsible counsel to conclude that serious allegations could properly be based upon it. I could not think, for example, that it would be professionally improper for counsel to plead allegations, however serious, based on the documented conclusions of a DTI inspector or a public inquiry, even though counsel had no access to the documents referred to and the findings in question were inadmissible hearsay. On this point, I would accept the judgment of Mr. Justice Wilson. And Lord Steyn comes to the same conclusion at paragraph 34 on page 138. Towards the bottom, letter G, 138, the substance of the case against the barristers was that, contrary to para 606 of the Code of Conduct, they made allegations of dishonesty against the litigant without having before them reasonably credible material, which, as it stands, establishes a prima facie case of dishonesty. I think if one picks it up at the bottom of the foot of that page, the last sentence, often the decision will depend on circumstantial evidence. It may sometimes be finely balanced. What the decision should be may be a difficult matter of judgment on which reasonable minds may differ. And then at para 45 on page 140, he says, for the reasons given by Lord Bingham and Lord Roger, as well as the reasons contained in this opinion, I would allow the appeals. Lord Hoffman, at para 46, agrees also, my lords, I've had the advantage of reading in draft the speeches of my noble and learned friends, Lord Bingham and Lord Steyn. For the reasons they have given, I too would allow the appeals. Lord Hobhouse, at para 69 on page 149, says there has been a discussion whether para 606 is satisfied by an expectation of obtaining admissible evidence which has not yet been obtained. I do not wish to enter upon this discussion, save to say that it is misconceived. The emphasis should be upon whether the existing material discloses a prima facie case, which is a concept well understood in many areas of procedural law, not least in the criminal law. The question which the advocate must ask is there a prima facie case of fraud which I am going to allege? That's based on existing material. And then one turns to Lord Roger at 151, para 77. The majority of the Court of Appeal held that the appellant's conduct in drafting the amended notice of appeal on 3rd February 2000 and in preparing the skeleton arguments the following day had been improper in the terms of section 51(7)(a). That decision was based on the view that their conduct on those dates was governed by paragraph 606 of the Code of Conduct. Paragraph 606 provides that before making any allegation of fraud, counsel should have before him reasonably credible material which, as it stands, establishes a prima facie case of fraud. The majority held that in terms of the rule, the material had to be evidence which can be put before the court to make good the allegation. Since it was clear from what happened subsequently that no such evidence had been available to counsel on 3rd and 4th of February, the majority held that counsel had breached the rule in paragraph 606. The interpretation of paragraph 606 that the majority adopted is perhaps not surprising, since the rule of professional conduct was formally understood to be to that effect. For instance, in an associated leisure case, Lord Denning indicated his understanding that the duty of counsel was not to put a charge of fraud on the record unless he has clear and sufficient evidence to support it. And this passage is cited in Bull and Leek's precedents and pleadings. The same approach is to be found in the extrajudicial remark of Lord Macmillan that where a person's reputation is at stake, the pleader should not trespass a hair's breadth beyond what the facts as laid before him and duly vouched and tested will justify. Para 79. But the current rule is that stated in paragraph 606. Mr. Justice Wilson held that the term material in para 606 went wider than evidence in proper form. The paragraph states a rule of professional conduct rather than a rule of law, but I agree with his interpretation of it. The current rule of conduct is slightly less strict than the rule as at one time understood. While usually the material before counsel will comprise evidence in an admissible form, something less can satisfy the requirements of the current rule, provided that it establishes a prima facie case of fraud. A report of an official inquiry or accurate reports of evidence given in a civil or criminal trial are examples that come to mind. A professional rule that permits counsel to draft pleadings on such a basis before the actual evidence is to hand achieves a sensible balance. It gives due protection to defendants while not putting unnecessary obstacles in the way of claimants and their counsel raising proceedings promptly. So interpreting the rule, I am unable to infer from the circumstances that the appellants were necessarily in breach of it on the 3rd or 4th February 2000. So what we see from this is that there needs to be credible existing material, not necessarily admissible in a court, but existing material which leads to responsible counsel to consider that there is a prima facie case of fraud. And as I say, that is the test which was proposed by counsel in the Sefton case, which I would ask you to turn to now, which is in the second volume of authorities.
Do we have a copy of paragraph 606 of the Code of Conduct? Because I noticed that allegation of fraud was subheading C. There were two other allegations that were covered by the paragraph, and I just wondered what they were.
The answer to your Lordship's question is no, but we should be able to obtain it over the end of the lunch adjournment.
Thank you.
I don't turn round to see whether it looks on the face as it goes. Whose job it is to find it, but there we are.
So it's containing C. We haven't got A and B.
No. My learned friend, so much more up to date than I am just about everything, tells me there is now a new Code of Conduct. So we'd have to find the...
Yes, the Bar Standards Board, I think, has a Code of Conduct which may have superseded this.
Yes. That seems to be the position. So, if we turn to Sefton in Authorities Bundle 2, tab 16, I just read the opening bit of the...
Can you give me a page?
So sorry, 556. 556.
Thank
you. Behind tab 16, 556. To set the scene, the solicitor practising on his own engaged the defendants as his accountants for the purpose of preparing and certifying annual reports containing the information prescribed by the Accountants' Reports Rules 1986 and 1991, which the solicitor was required by statute to deliver to the Law Society. Between 1989 and 1995, the partner at the defendant signed 8 such reports, stating that he had examined all the relevant documents of the solicitor's practice and that he was satisfied that the solicitor had substantially complied with the solicitor's accounts rules. In fact, the partner did not examine the relevant documents, and between 1990 and 1996, the solicitor misappropriated a total of over £750,000 from his client account. When the Law Society discovered the solicitor's fraud in May 1996, it intervened in his practice and he was subsequently struck off the roll. In July 1996, a former client of the solicitor made a claim for compensation from the Solicitor's Compensation Fund, of which the Law Society was a trustee. Over the next 3 years, the Law Society made payments out of the fund, compensating former clients of the solicitor for the sums they had lost through his misappropriations. I think if we then drop down to the holding against letter G, held allowing the appeal, Lord Justice Neuberger dissenting, that there was a distinction between measurable relevant loss, which when suffered did result in a cause of action in negligence accruing for the purpose of Section 2 of the 1980 Act, and the mere risk of loss, which of itself did not. That although the Law Society suffered a risk of loss on receiving each report from the defendants, and as a result permitting the solicitor to continue in practice, which increased when the solicitor thereafter misappropriated clients' monies, it did not at that stage suffer actionable loss. That therefore the Law Society's cause of action in negligence in relation to each report accrued on the date on which it resolved for the first time to pay from the compensation fund compensation to a client whose money had been misappropriated after the report in question had been provided to the Law Society, and that accordingly the claim in negligence was not statute barred. Now, the head note doesn't deal with the point with which we are concerned, which was reasonable. When was the fraud reasonably discoverable? When was the negligence reasonably discoverable? And this was an appeal from my Lord Briggs, as he then was sitting as a deputy judge. And if one looks at page 558, you see Timothy Dutton and Rosalind Phelps for the Law Society. And one turns over to 559. Between letters E and F, below the middle of the page, as to the fraud action, the limitation period is prescribed by Section 32 of the 1980 Act. The period of limitation doesn't begin to run until the plaintiff has discovered the fraud or could, with reasonable diligence, have discovered it. There was nothing in the Society's knowledge prior to June 2002 which should have led it to suspect that the representation of the defendant firm might be fraudulent. A party cannot be said to have discovered the fraud within the meaning of Section 32 until it has in its possession materials which would make it professionally proper for a plea of fraud to be advanced within the guidelines laid down in Metcalfe and Mardell. So that's what they were saying, that they weren't in that position. And then over the page at 560, as to fraud, this is a last paragraph, letter B, as to fraud, the test to be applied under Section 32 of the 1980 Act is whether within 6 years of the issue of the second claim form, the Society discovered or could with reasonable diligence have discovered the fraud. The fraud could with reasonable diligence have been discovered by December 1996. It was the Society's own decision not to start to investigate the possibility of fraud until late in 2002. So I'm so sorry, I missed out. That was the defendant's claim.
Yes.
That appeared at letter G, below what I read before. So that was how the argument was raised. And then one goes to Lord Justice Neuberger, for whom this was material, because his view in the minority was that the cause of action had accrued much earlier, when the Law Society was at risk of payment, and that was the view of my Lord Briggs in the Chancery Division. And that was the minority view. But because that was Lord Justice Neuberger's view, he deals with this issue of constructive discovery, because that was material. If constructive discovery was later, then that would be helpful. So it goes, if one turns to page 562 in the manuscript, it would be helpful just to note at para 11 one key point. As a result of Mr. James's report, the Society immediately wrote to Mr. Mascord seeking an explanation and intervened in Mr. Payne's practice on 20th of May 1996. This intervention effectively involved taking over Mr. Payne's practice, including all the accounts and papers. Unhappily, Mr. Mascord committed suicide. Mr. Mascord, I think, was the accountant personally responsible for this. So at that date, 20th of May 1996, the Law Society had all the accounts and papers. And they knew, because the complaints had been made, that there were defaults in the client's account. One drops down to H on that page, para 15. The facts set out above are sufficient to deal with the first issue, namely when the Society's causes of action in negligence accrued. But it is now necessary to set out additional facts in order to deal with the other two issues, namely when time began to run in relation to the causes of action in fraud, and whether the defendants are stopped from relying on the 1980 Act. We're not concerned with the estoppel, we are concerned with the time running in relation to the causes of action in fraud. One turns to 565, para 29. Counsel advised that it would be proper to plead for fraud on the basis that Mr. Mascord could not have carried out the work required by the accountant's report rules and therefore could not have honestly stated in each of the reports that he had done so, provided that Barlow's were first asked to disclose Mr. Mascord's working papers. If Barlow's refused to disclose those papers, that's Barlow, Lyde and Gilbert, who were acting at that point for the accountants. If Barlow's refused to disclose those papers, or if the papers were disclosed and showed that Mr. Mascord had not carried out the work he said had carried out, the advice was that proceedings for fraud could be brought. In effect, it appears that counsel took the view that armed with a refusal to provide the working papers or with helpful evidence from the working papers, there would be sufficient to plead fraud in light of the state of Mr. Payne's accounts, the suicide of Mr. Mascord, and the apparent repudiation of liability by Mr. Mascord's insurers. So when he turns to 568, where he now deals with explicitly with the first issue, when did the Society's cause of action in negligence accrue? And then turn to page 586. There's a lot of detailed material before that dealing with exactly what happened. Second issue, when did the Society's alleged cause of action in fraud first accrue? That's at page 586. Para 109. As in relation to the claim in negligence, it was rightly common ground between the parties that if the Society had a claim against Seftons in fraud, they were the accountants, a fresh cause of action arose out of each report. The claim in fraud being in tort is governed by Section 2 of the 1980 Act, but the conclusion I've reached in relation to the claim in negligence doesn't necessarily apply to the claim in fraud. This is because the date when the cause of action in fraud becomes time-barred depends on Section 32 of the 1980 Act, which provides, so far as relevant, 1. Where in the case of any action for which a period of limitation is prescribed by this Act, the action is based upon the fraud of the defendant, the period of limitation shall not begin to run until the plaintiff has discovered the fraud or could, with reasonable diligence, have discovered it. Para 110. As the judge said, a claimant does not discover a fraud until he has material sufficient to enable him properly to plead it. Authoritative guidance on that topic was given by Lord Justice Millett in Paragon, in the passage cited by the judge. The question is not whether the plaintiff should have discovered the fraud sooner, but whether they could, with reasonable diligence, have done so. The burden of proof is on them. And this is a passage which my learned friend took you to. But para 110 is key. Material sufficient to enable him properly to plead it. That was the expression used by my Lord Briggs, which was the formulation which had been agreed by counsel in that case to be appropriate. One turns to para 586. page 587, paragraph 118. Foot of the page, I turn then to the judge's third step. The essence of his reasoning was that, bearing in mind the time that the society actually took between the date on which the possibility of alleging fraud surfaced in the mind of the society and its advisers and the date on which the proceedings in fraud were actually begun, namely the 2nd December 2002, the society had failed to persuade him that it could not, with reasonable diligence, have discovered the fraud within the same period, measured from the date of the intervention in the practice of Payne & Co. In that connection, it's important to bear in mind that with effect from the date of intervention, 20th of May 1996, the Society had access to all the papers and records of Mr. Payne's practice, because, as it was entitled to do under Schedule 1 to the 1974 Act, the Society took possession of all those papers and records. And then if one drops down to letter E, fourth word in from the left-hand column, what the judge was saying was that even bearing in mind that in 1996 the CPR didn't apply, and that there was therefore no right of pre-action disclosure, there would have been enough to establish a prima facie and therefore a pleadable claim in fraud, in light of the other facts available by drawing an adverse inference from a refusal by the solicitors acting for Seftons to produce the documents sought. So it's clear that Lord Justice Neuberger, as he then was regarding the test as having sufficient material to establish a prima facie and pleadable claim in fraud. Then one turns to Lord Justice Morris Kay at 591, page para 133. In his judgment, Lord Justice Neuberger has set out the preliminary issues before the judge which are the subject of this appeal and the factual and legal background in which they arise. I agree with his conclusions and his reasons in relation to the second and third issues, namely as to when the cause of action in fraud arose and as to whether Seftons were stopped from relying on any limitation point. However, I've reached a different conclusion on the first issue, namely the date upon which the Law Society's cause of action in negligence accrued. And Lord Carnwath at 595, paragraph 150, says, like Lord Justice Morris Kay, and in disagreement with Lord Justice Neuberger, I differ from the judge's admirable judgment on one point only, that is the date when the cause of action accrued. Against the background of Lord Justice Neuberger's comprehensive review of the facts and law, I can express my reasons shortly. The matter did go to the House of Lords, but as they upheld the majority, they did not express any views on the other point. I'm not sure whether it was argued or not. May I now invite you just to refresh your memories as to Section 32 of the Limitation Act, how it's expressed, and to compare and contrast with Sections 11 to 14A, which deal with personal injuries and latent defects, which are the subject, the latter being the subject of the AB Ministry of Defence case. This is in authorities.
You're going to tell us at this point what you get out of Sefton, are you?
I beg?
You're going to tell us what you get out of Sefton at some point.
But what I get out of Sefton is that so far as fraud is concerned, the appropriate test of discoverability is when there is existing material sufficient to raise a prima facie case that there has been fraud. That is a case on Section 32(1), subsection 1A.
How do you apply that to this case?
By applying precisely the same test, that when there is sufficient existing material to raise in the minds of competent lawyers or accountants that there is a prima facie case that the payment has been made under a mistake of law, a prima facie case that the law was mistaken at the time. At that point, time begins to run. How that applies to any particular case will depend on the state of affairs. For example, if HMRC were in 2003, to have published a notice to say that in the light of the Hearst decision, they are going to revisit all matters relating to payments of dividends and taxation on them involving a European element, perhaps that would have raised a prima facie case. If HMRC are doing that, that means they've taken the view that the law was wrong. That might be the equivalent of say, some commission report, which was referred to in the...
So it's not the final determination as such.
Not necessarily. No, it would depend on the particular case.
It might be said against you that the elevated test for pleading fraud is sui generis, because it all depends, it all derives out of the public policy need to avoid litigation descending into unsubstantiated allegations and cross-allegations of fraud, and that it's not immediately obvious why the same elevated requirement should apply to an allegation of having made a payment under a mistake of law.
Well, that was why I asked about subheads A and B in Code of Conduct, para 606,
Yes,
to find out what was the true extent to which this requirement of prima facie case prior to pleading, what was the range of its application?
Of course, I understand what your lordship is saying, but we're looking for a test. This is on the hypothesis there is a test. I mean, if you take the view that as soon as the payment is met, well, take the view that 32(1)(c) doesn't apply to mistakes of law, I can sit down and let my learned friend argue about res judicata, which is much, but let me hypothesize that you're not taking that view at this stage, so that this is relevant. There has to be a test. The test laid down by the Court of Appeal suggests where there is some determinative decision of a court. What I'm saying is that may be, in the circumstances of the case, appropriate, and it is in this case. It is the decision of the ECJ in FII, but that isn't necessarily a principled and practical criterion. The criteria ought to be a broader principle in my submission, or could be a broader principle, and that's why I'm saying, when you're dealing with a mistake of law, what are you looking at? You're looking at something which is intangible, and we don't know what it is, ex hypothesi, in a case such as the present, where there has been a challenge to UK statute on the basis that it infringes certain articles in the European Treaty. We don't know what the law is. As Lord Hoffman said, the law isn't there until the mistake isn't there to be discovered until we know what the answer is. So in this sort of case, there may be other cases of mistake of law. But in this sort of case of mistake of law, it is reasonable to say that once there is a prima facie case, something which indicates there's a prima facie case, then at that point, the claimant's time must start to run. Now, the Limitation Act gives 6 years. That may be a long time, but that's what the Limitation Act says, and the government did not act on the Law Commission's recommendation that it should shorten that period to 3 years. But that's what we're dealing with. That's what Parliament has decided, and that's what the government decided should remain in place. So I'm just suggesting that is a reasonably principled approach, since it arises in the context of Section 32, 1A, and there may be other provisions in the Bar Council's code, I don't know. It's not a bad test. Now, I'm not sure whether I need put the bar any higher. If you can think of a better test, fine. We might have 7 tests. The nice thing about the House of Lords was that, I'm sure my Lord Carnwath remember, but there was an endless stream of cases dealing with Furness and Dawson about tax avoidance, etc., etc. And every time a tax avoidance case came up, you had to go through this complete litany of cases. And I remember standing in the House of Lords saying, can you please put an end to this by adopting a very simple rule? I think it was Justice Ribeiro in Hong Kong, read the law purposefully and apply it to the facts viewed realistically. That's all they're saying. Now, there are 7 of your lordships here. If you can come up with a test that's better than the one I'm proposing, please do so. But just to say, well, there's a sort of a sniff that maybe the law is wrong here, that we gather that slaughters are bringing an action against HMRC in relation to group income. We gather that. We don't know because we can't actually see the papers. As it happens, I can. I actually settled the writ in that case, as it happens. But at that stage, lawyers here hadn't a clue where that was going to go. And it was very specifically dealing with the group income election. So at that point, no one had any idea that credit should be taken for foreign tax and pumped into our ACT, franked investment income system, in the way that my learned friend has indicated. No one had the faintest idea about that. When did that emerge? Well, the answer to that is when the ECJ gave their decision in FII. And then, wow, it was there to be seen. That was the prima facie case. It doesn't mean that the claimants in this case would recover. There was a prima facie case they might recover, could recover as a matter of law, that there had been a mistake of law, but could they recover? The revenue have put forward defence after defence after defence after defence, including the one which your lordships, or this maybe a different panel, will be hearing in December, to say that no, nothing is recoverable. He actually said himself that one of the issues, the Pirelli issue, as I think he called it, the fact that the tax credit is paid out may scupper the whole thing. So that is why I'm not comfortable with the proposition as when the final court rules, because the final court ruling may well be a different panel of this court in December. That takes us way, way, way beyond when we had the decision of the ECJ on the point of principle.
No, I mean, I just wanted to clarify that, and it's very helpful. But I mean, where in your case is the sort of your current formulation best expressed, just for the sort of?
I think it's best expressed in the transcript of this morning, if I may say so.
I'll await with eager anticipation. So, I mean, without any distraction, it is sort of, you're feeling your way, as we all are, I think.
I'm feeling my way. I'm uncomfortable with the suggestion that it's when the final Court of Appeal rules, because we've seen there's no finality. In the thin cap case, the ECJ gave a decision in favour, we thought, of the clients. It turned out that another decision of the ECJ, subsequent to that, was regarded by the Court of Appeal here as superseding the first one. So I would say in the thin cap case, it's when the first decision was made where we thought, whippy, we've won. And not when the Supreme Court actually, despite the fact there was a division of opinion in the Court of Appeal, considered it act clear that we had lost, which was, and refused to hear the case and wouldn't refer
Let's
it.
not go back over that.
Well, I'm sorry, but the shoe still pinches, I'm afraid.
You're very conscious.
So that's why I am conscious of the need for some principled criterion rather than just a statement of it's got to be the final court. And it seemed to me, reading Sefton's, I thought through properly to be pleaded, hang on a second, this is section 32. When I appreciated that my learned friend's arguments based on section 14 were completely off beam, because that is dealing with a very specific set of provisions and the word attributable, which has been given that long judicial meaning, which I'll take you to section 14 in a second and show you. I thought, so I said, well, hang on a second, maybe there is something in Sefton that works. It works. I'll come to what was said in DMG. Lord Brown uses different expressions, like when there's a sort of a good chance or a strong, some formulation of word. You could say a reasonable chance of success, something like that, when it when it is reasonably apparent that there's
Worthwhile.
worthwhile.
Yes,
Crikey.
I mean, the advantage of Sefton, I mean, you know,
Yes.
I do attend to the fact you both seem to be sort of focusing on Sefton with slightly different results.
Yes.
But as opposed to Section 14, is that a sort of different context?
Would you say it's
different word?
worthwhile commencing an action if you were told in 2003 or 2002 that by the time you get to 2020, your costs, even though there's been recovery against the Crown, your costs are going to be in millions and millions and millions?
Well, yes, but you'd also be told your recoveries by then might be in billions and billions and billions.
Subject to what the Supreme Court does with compound interest
Yes.
and everything else,
Sure.
absolutely. You know, but whether it's better to get scratch cards and put your money on it and hope you'll actually earn more that way. I don't, but I'm saying there needs to be something, just to say a sort of a good chance of success. It's too amorphous.
So do you disagree with the appellant's expression of the Sefton test, which is a paragraph 1022, 3951?
This is in their case.
Yeah.
Oh, sorry, you mean in their
Case, yeah.
in their case? Right, I've got to find their case.
That's what they call the Sefton test of discovery. 3951. Page 37 of their case. To subparagraph 2.
Yes,
Do you agree with that?
yes. The Sefton test, a fact or proposition of law is discovered by the claimant on the first date that the claimant is in a position to plead a statement of claim, asserting or depending upon the proposition of law without the claim being struck out. Well, that is putting the bar so low that one would just trip over it without even seeing it.
That's the discovery test. I think that the discoverability test sort of sits on the back of that.
Yeah, exactly.
Yes. That isn't the Sefton test. It's talking about properly pleading fraud. You can't extrapolate from that. Well, then you can properly plead something else that isn't fraud, which has a totally different bar that has to be overcome.
Sorry, it's my fault.
Sorry, are you saying that it's not the Sefton test?
Yes.
Well, I don't think what they're doing is expressing the Sefton test in a much broader way, just saying when in any case you can properly plead something without being struck out, that's good enough. Well, you can plead a mistake of law if you wanted to almost every day of the week, and unless the case is absolutely hopeless, it's not going to be struck out. The judge is going to say, well, you know, if that's what you believe the law is wrong on this, you're entitled to test it. I would say the test, as it is expressed in Sefton, it is I forget the name, the Mardell, what's it called? The Metcalfe and Mardell test, which is the one which was adopted. When it's properly, when as in Sefton, it is proper to plead fraud.
Or in this case, proper to plead mistake of law. It's the same question.
Yes, but proper to plead it when there is prima facie, when you have existing material which evidences or evinces a prima facie case that there has been a mistake.
And how does that fit with the observation you just made that you can plead mistake of law any day of the week? I mean,
It does fit, because of course you can
even before
the
Herc's decision, it could have been proper to plead mistake.
It could have been proper to plead it before Hearst. It could have been pleadable in 1975.
So it's my fault, but I'm now
But
slightly at a loss of
well,
what
put
you're
yourself
saying your case
that
is.
in 1973, when we entered the European Economic, whatever it was called, Common Market. 1973, the Treaty of Rome, or whatever it was in force. Someone at that stage could have thought, crikey, I wonder whether this impinges on our taxes, and claimed all their tax back in circumstances where there was thin capitalisation or anything like that. You could have done that. But there was absolutely nothing, no existing material to raise any prima facie case that the taxes were being raised improperly. It was only when, in Hurst, the Court of Justice gave its decision that those companies who had suffered because they weren't able to make a group income election had material raising a prima facie case that they were entitled to get their tax back.
I mean, I noted your submission in answer to Lord Lloyd Jones's question that the relevant test is when is it proper to plead mistake of law? I mean, it wouldn't be
that was not my. Maybe I shouldn't look at the transcript because that's what I said. That is not what I was intending to say.
You went on to say when you have existing material which evinces a prima facie
Yes,
case that there's
exactly. So not that you're entitled to argue the matter without being struck out, because when it's an issue like that, which judge is going to strike out a claim in 1973 by someone saying, "Oh, we're subject to the Treaty of Rome," that impacts. No one's going to strike it out.
But the focus in Sefton is on the, and in Medcalf and Mardell, is whether you've got the existing materials.
Yes.
In relation to an intensely fact-intensive question.
Yes.
If the question is a question of what the law was at the material time, one's tempted to think that the existing materials are just the Treaty of Rome plus the English statutes and then putting the two together and working out how to produce a conforming construction, which is what everybody's been engaged in at great time and expense ever since. But you're looking for some other kind of material.
Oh, yes, yes.
And I'm not sure whether you're saying this case is one of retrospective judicial legislation, the judges here being the judges of the European Court, or is this a true declaratory case where the law always was like that from 1973 when we joined the club? You may say that, why am I asking? But it seems to me there could be quite an important distinction between this case and, for example, Kleinwert-Benson, which on any view was a case of judicial retrospective legislation.
Yes.
Whereas this might not be if one says, well, it's just a question of comparing the Treaty of Rome and our legislation, and coming up with a conforming construction of it.
My lord, it would be, we're talking about the payment being made under the misapprehension as to what the law was, a mistaken misapprehension. And you're saying that you could appreciate that you had prima facie case on my test, that you have made a mistaken misapprehension simply by reading the Treaty of Rome, ignoring the fact that taxation was one of the red lines which the UK government was insisting upon that the European Union common market would not impinge on, assuming there's going to be a conforming construction and not a disapplication, and all these things. And at that stage, all that was available material, existing material. I said, well, that is an unrealistic test.
Can I ask, when you talk about existing materials, the example you gave was the decision of the ECJ in Hurst, where we have a legal decision, legal ruling by a court of final jurisdiction.
And if it were to be a material ruling in relation to this case, then the Hurst would be, the decision of the Court of Justice in Hurst would be the starting point. For reasons I'll come to, I say it isn't,
Well, yes,
But it could be. It could be. There's no question
Well,
it could be.
yes,
It was described by
thinking
Lord
about
Walker as
the-
a thunderbolt from Europe.
yes, I'm thinking about the difficulty of the inherent uncertainty of this test. I mean, on one view, you might think, for example, I don't know, the opinion of counsel or an article in a legal journal might be material from which you could be alerted to the possibility of a mistake and think of bringing proceedings. Or there might be, I mean, in the present case, you're arguing for, well, it doesn't really matter to the BAT clients, but the Court of Appeal thought that the appropriate date was the FII
Yes.
judgment. Mr. Justice Henderson thought that it was the judgment in Metallgesellschaft.
Yes, that's a Höchst case, yes.
Höchst.
Höchst, Metallgesellschaft.
I mean, one can imagine cases where you could have a decision which wasn't directly on point, but which nevertheless pointed sufficiently clearly towards the conclusion that it would put people, it make people realise that there was an arguable point here.
Yes, strongly arguable point, I would say, yes.
We're trying to fix on a particular date is going to, strikes me as something that's going to be very, very difficult to do.
Well, my Lord, with respect, I suggest it's perhaps more difficult to frame the criterion than it is to apply the criterion.
Yeah.
Applying it in this
Right.
particular case isn't that difficult, and I'll come to Höchst to explain why it is not a guideline for FII and why FII happens to be, the decision of the ECJ and FII happens to be the case, the relevant case. But there is a spectrum. If you take my Lord Briggs's view, well, the Treaty of Rome was there. We know it's going to be may well be amended over time, but it was there in 1973, and we had the ACT system set up in 1973. So surely, you could have put two and two together.
No, I'm not putting it that high. I'm just trying to find out what the materials are said
Well,
to be.
well, I'm saying that those materials do not produce anything like a realization that there's been a mistake. They could do. You could have hydrogen and oxygen in two different cylinders, and you could say, well, potentially you've got water. The hydrogen's there, the oxygen's there, you've got water. But until whoever it was decided when you put them together you get water, you don't know. It maybe not the best analogy I've come up with in my career, but I'm trying to say that the raw material, it depends how raw you want the raw materials to be. What my Lord in the Chair has said, there might be an article. Yes, there might be an article. There might be an article, but there wasn't. There might, what happens in tax is very often there are statements by the revenue. They publish them all the time. They can say that having taken further advice, they no longer adhere to a position they've taken in the past. That's been done. That might have occurred, but didn't occur. It wasn't until, on the facts of this case, it wasn't until the decision of the Court of Justice and FII that there was an obvious point to be made that ACT could be reclaimed and D5 tax could be reclaimed. Whether you succeed would depend on all the defences which the revenue are putting up, including change of position, which they lost on the facts. All the defences failing.
Well, of course, the test isn't obviousness. We're talking about reasonable diligence.
Yes. Yes, would it be regarded as reasonably requisite diligence in 1973 to have wondered whether they could refuse to pay ACT straight away on the basis that we've entered the common market. It's not an easy task. I mean, there is no easy answer. I've suggested a prima facie case is a reasonable test to adopt because, by definition, if you have a prima facie case, on the face of it, it looks as though you have a claim. And when you're dealing with a mistake, because by definition a mistake is something which is mistaken, you don't know what the position is, it's when on the face of it you can see that you've made a mistake or are in a position to see that you've made a mistake, on the face of it, that's when your time begins to run. 6 years is probably not an unreasonable time, having regard to the complexities of the issues involved in cases such as these. Not an easy task. I said I was going to take you to section 14, but I don't know if I need to or not. It became pretty apparent in the AB case what the section was saying. If it would help your lordships, I would take your lordship to it just to show the various provisions that were referred to in the AB case. Or perhaps you might find it easier, more helpful if I took you to the Hurst case, where you can see why, although that was a thunderbolt from Europe, as described, using the expression of Lord Walker, I think in Pirelli, there was no lightning strike so far as tax credits are concerned in this case. And I can show you that because you remember my learned friend in opening was explaining that ACT, when it was introduced, advanced corporation tax was the reciprocal of the tax credit that was given to the shareholder. The dividend is paid, ACT is paid on the dividend, the shareholder gets a tax credit. And if the shareholder is a lower rate taxpayer or exempt, actually gets the money back. He said that was the system, that was the conceptual system. And it was part of it. It was slightly more complex than that, but that's right. In the Hurst case, the issue was that within a group of companies, there was a mechanism called a group income election where you didn't have to pay the ACT, but no credit was paid. And that wasn't available where the recipient was a non-resident. One of the points claimed in the Hurst case, one of the points put to the ECJ was, well, if we can't make a group income election because the parent is German, can the German parent get a tax credit? Because if the revenue are saying, as they did say in their defense, ACT is the reciprocal of a tax credit, and there's no tax credit being given to the Germans, so why should ACT? It's the reciprocal. The German company is a non-resident company, and that's the end of the matter. So the German company, Hurst and Metallgesellschaft, said, well, if we lose on the fact that we have to pay the ACT, can we at least get a tax credit for the parent company? That was issue 3, if I remember rightly, put before the ECJ. The ECJ said, or the Advocate General Fennelly said, I don't need to discuss that. That's an extremely complex issue. I don't need to discuss it because I have come to the conclusion that ACT should not have been paid. A group income election should have been allowed. So I'm not going to go into that very complex issue. But that complex issue was relatively simple, you might think, because that's what ACT was all about. That complex issue was argued in a case called ACT Class 4 GLO. I remember it very well because it was on an extremely foggy day in Luxembourg, where one of the team had to travel by coach from was it Frankfurt? I forget where it was. You had to actually get a coach because the planes couldn't fly. That case lost. It lost. So the very complex point, which Advocate General Fennelly did not want to get into, was taken and lost. The Court of Justice simply didn't deal with it. Just as the point doesn't arise. didn't make any comment as to whether it was complex or otherwise. So that's why Hurst itself is not the wake-up call. There might have been a thunderclap saying we've got to start looking at the to see now whether our dividend system is valid in its entirety or whether it has to be modified. But Hurst itself did not deal with tax credits. It's a totally different concept to argue, as we argued successfully, that tax in another state should be regarded as corporation tax paid in the UK. That was our argument. It's a pretty bold argument. They're saying they paid tax in France, they paid tax in Germany, they paid tax in Greece, or wherever. I suppose they didn't pay tax in Greece, let's say Germany and France. They paid tax over there. That is the equivalent of corporation tax here, and therefore you ought to feed it into the FII system. It was a very bold argument, and an argument which succeeded. So I'm not sure whether I've assisted my Lord Briggs, but I would say that to say that the existing material when these payments were made from 1973 onwards was sufficient to alert competent advisors that there was a prima facie case or a good case of recovering ACT on the basis of foreign corporation tax. That would have been a crystal ball. It would have been a profit, P-H-E-T, to have said that. Now, I've really made quite a lot of submissions in that, in answering your Lordship's points. Would it help if I now actually went to some of the authorities? I'm conscious of the fact that my learned friend here has a lot of stuff to get through on the res judicata, so can I do it fairly quickly?
We're looking at authorities on what now?
I'm just going to take you to Hurst, just so you can see the point made about the tax credit being the reciprocal and how Advocate General... Well, I can. It's in Authorities 2 at tab 24, MS 807, I hope. And if one turns to MS 815, paragraph 13 of the Advocate General's opinion, you'll see the questions, and over the page, the main question is question 1. In the circumstances set out in the order for reference, is it consistent with community law and in particular Articles 652, etc., for the legislation of a member state to permit a group income election allowing distributions to be paid by a subsidiary to its parent without accounting for advanced corporation tax, only where both the subsidiary and parent are resident in that member state? The answer to that is it is not permitted. That was his answer. Over the page, you'll see question 3. In the circumstances set out in the order for reference, is it consistent with the above-mentioned provisions of the EC Treaty for the authorities of one member state to deny any tax credit to a company resident in another member state when it grants such credit to resident companies and to companies resident in certain other member states by virtue of the terms of double taxation conventions? So that was the claim for the German parent to get a credit. Para 15 on page 817, you get the Advocate General's overview saying the claimant's fundamental claim is that the UK subsidiary's exclusion from the possibility of making a group income election on the basis that their parent companies are resident in Germany were incompatible with the freedom of establishment. Counsel for the claimants stressed at the oral hearing that the alternative claims were wholly subsidiary to this principal claim. And then if one turns to paragraph 57 on page 835, questions 3 and 4 concerning tax credits, in view of the recommendation that I have made in respect of the principal claim brought in the main proceedings, I do not consider it necessary to consider the extremely complex issues raised by the alternative claim in respect of the possible entitlement of the German parent companies by analogy with the double taxation convention applicable between the UK and the Netherlands to a partial tax credit in respect of advanced corporation tax paid by United Kingdom subsidiaries. You can see these are seriously complex issues. One turns to 837, which is the beginning of the judgment of the ECJ itself, and they deal with this at 852. Towards the footer of page 852, the third and fourth questions, in light of the answer given to the first question, it's unnecessary to reply to the third and fourth questions. So they weren't prepared to deal with the tax credit issue at all, the extremely complex issues raised by it. And as I say,
Could you give me the page reference for that?
I'm so sorry,
852.
Thank you.
what I've just read.
Yes, I've got it.
Does your lordship have it? I'm sorry.
Yeah, thank you.
Thank you. And in the respondents' further supplementary authorities, which is further supplementary memory stick page number tab 3, further supplementary memory stick page number 35, is the claim that was not dealt with in Hurst. Oh, no, sorry, where's the ECJ decision? Sorry, that's not it. It was referred, maybe this is the reference. Anyway, it was referred to the ECJ and the claim failed. There was no right under European law for the German parents and other parents in a similar position to recover a tax credit from the United Kingdom. So can I just make, just make one brief reference to DMG itself. Can I just mention something? My learned friend refers to Mr. Bezic, saying Dr. Bezic has produced the only paper dealing with the question of discoverability of mistakes of law. I think that was what he said. If you look at it, Authority 2, tab 25, just after Hurst, isn't it? I think conveniently. If one looks at page 865, right, you'll see footnote 70. Refers to the FII case, and you'll note a little note at the end of footnote 70. Page 865 in the memory stick. Note, the author contracted legal services to HMRC Solicitor's Office in 2015-16, although he did not have charge of this litigation. He was the main liaison person at HMRC dealing with this litigation. He may not have had charge of it, but he was. Now, I'm not suggesting for one moment that has influenced his views, but you can see that he was actually running this case, or not technically running it, but as a contractor, presumably no PAYE during that particular period. But he was the main liaison person dealing with this case at that time. So if he developed a view as to whether HMRC were right or not, it's not entirely surprising. If I can just now go back to DMG, which is in Authorities 1, that's tab 11. Just to remind your Lordships how their Lordships in that case approached the issue of discoverability. One goes to manuscript page 2, not manuscript page, memory stick page 272. You had Lord Hoffman. A few brief references, then we can look at what Lord Brown says, because he was taking a different approach. Para 31, if DMG made a mistake about the law, when could they, with reasonable diligence, have discovered it? On this question, it's important to bear in mind the special nature of the mistake, namely that it was deemed to have been made because of the retrospective operation of a later decision of the Court of Justice. The reasonable diligence proviso depends upon the true state of affairs being there to be discovered. In this case, however, the true state of affairs wasn't discoverable until the Court of Justice pronounced its judgment. One might make guesses or predictions, especially after the opinion of the Advocate General. This gave DMG sufficient confidence to issue proceedings, but they couldn't have discovered the truth because the truth didn't yet exist. In my opinion, therefore, the mistake was not reasonably discoverable until after the judgment had been delivered. So he's not saying there that you have to wait to the final judgment. He was just saying that it just wasn't reasonably discoverable until the Court of Justice pronounced its judgment. There might have been other circumstances which would have made it reasonably discoverable, but they weren't there. Lord Hope at 283. Para 66. The argument that DMG simply took the risk that it might have been wrong when it made the payments was considered and rejected by Mr. Justice Park. He held in paragraph 30 that DMG didn't discover its mistake in 1995 when it learned about the argument that Höchst was advancing. It didn't do so until the decision in the Metallgesellschaft-Höchst case was released by the European Court on the 8th of March 2001. And then over the page, para 68, Lord Hope says this below letter F. There seems no good reason why cases of mistake of fact, the nature of which and the occasion of which, for the discovery of which can vary greatly, should not be treated in the same way for limitation purposes as mistakes of law. And prior to that, he quoted Professor Burrows. If one turns over to para 71, para 71 on page 285, it says, it's plain as the judge recognised that if DMG had submitted a claim for group income relief under section 247, the revenue would have pointed to the clear terms of the statute and rejected it. It's never been suggested that they would have conceded in the question with DMG the point which they were resisting so strongly in their litigation with Höchst. DMG's mistaken belief that a group income election was not available was not shown to be wrong until the issue which Höchst had raised was determined by the European Court on the 8th of March 2001. The issue, which was one of law, wasn't capable of being resolved except by litigation. Until the determination was made, the mistake couldn't have been discovered in the sense referred to in section 32(1) of the 1980 Act. In this situation, I would hold an agreement with Mr. Justice Park and Jonathan Parker, Lord Justice Jonathan Parker, that DMG was not in a state of doubt when it paid the ACT. It was not then obvious that the payments might not be due. They were made in accordance with the law as it was then understood to be. There was nothing yet to be discovered to the contrary, which could have been revealed by the exercise of reasonable diligence. And one turns to Lord Walker at MS 309. Under the heading "The Mistake Issue," he quotes Justice Neuberger, "For the issue of recoverability to turn upon a nice analysis as to the precise nature of the mistake of law appears to me almost as undesirable as it is for recoverability to turn upon whether the mistake made by the payer was one of fact or law." Again, just emphasising the closeness of the issues that arise. And then para 144, "I think the judge and Lord Justice Jonathan Parker were correct in their views that the mistake was not discovered until the European Court of Justice gave judgment in the Metallgesellschaft Hoechst case." And then perusal of the report in that case suggests that the United Kingdom government tenaciously defended the ACT regime on every available ground. At no time before the judgment did the government concede that the ACT regime was in discriminating between national and multinational groups contrary to EU law and unlawful. It was the judgment that first turned recognition of the possibility of a mistake into knowledge that there had indeed been a mistake. I agree with the view of Mr. Justice Lightman in the first Rood Hill leasing case that there may be cases where a party may be held to have discovered a mistake without there being an authoritative pronouncement directly on point on the facts of that case by a court, let alone by an appellate court. He agrees with that, and I am not dissenting from that either in my submissions.
But I mean, some of these passages don't seem consistent with the tests that you've been putting to us this morning, that the start point is when you have a prima facie case that can be brought, because these passages seem to be moving away from recognition of the possibility of a mistake, which looks more like prima facie test, into knowledge that there had indeed been a mistake.
Well, my Lord, then I have a different understanding of what a prima facie case is. My idea of a prima facie case is that on the face of it, you have a good case. There may, you may have to prove it and go through the courts to prove it, but you have a good case. Not that you have an arguable case. I wouldn't say a prima facie case is an arguable case.
It's an extraordinary paradox because they're using the declaratory theory to say there was a mistake because the judges subsequently did not change the law. That was always the law. That's why there was a mistake. That's why it's different from Parliament changing the law. But then they say when we turn to limitation, on the other hand, precisely because the court was changing the law years later, it was never discoverable until they'd actually done it.
Yes.
Yeah.
Yes. Yeah.
Well, one might think
but then you're looking at the policy of the Limitation Act and fairness, and you don't want people to launch claims as soon as someone says, hey, you know, maybe our entire corporation tax can be challenged on the basis of European law. You would then have so many claims being raised at a ridiculously early stage, and that can't be what the law is, that can't be desirable as a matter of policy. You want people only to make their claims when they have a realistic chance of succeeding. You don't want to encourage wholly speculative claims. Putting, especially against HMRC, I mean, their solicitor's office, or whatever it is now called, is busy enough. They certainly don't want to get another 20,000 writs, which they then have to tenaciously defend. That can't be the policy. So, although you say there's a paradox in a way.
Well, it's not really a paradox. It's deeply unsatisfactory, as the judges recognised. That's why they said legislation is necessary in order to address this.
Well, then the solution that was put forward was such a sensible solution, wasn't it, by the Law Commission? Give them 3 years from when you discover it and have an absolutely drop-dead date of 10 years from when the cause of action arose, which the government was apparently going to enact. Or you have Section 320, which simply strips it away in the case of tax, and introduce it properly with a transitional period, for heaven's sake, and save all the problems.
Aaron, again, it's my fault, but I am still struggling to understand what you mean by a prima facie case. So rather naively, I've always thought that a prima facie case is an arguable case, but you've made very clear that you're not using it in that sense.
No, I don't use it in that sense, no.
To help me, can you define what you mean by a prima facie case?
On the balance of probabilities, if this case goes forward, it is likely to succeed. Certainly, I would never plead fraud unless I was satisfied that the materials I had before me were such that if laid before a judge, the likelihood was that the judge would agree there's fraud. Not just suspicion of fraud, something which makes you wonder whether there might have been fraud.
I thought that was the point of the Metcalfe case, that your test here wouldn't have been satisfied in that case because counsel didn't have admissible evidence.
They did. It didn't have to be admissible evidence. That was the whole point. It didn't have to be admissible in a court of law. It had to be credible. It had to be existing material, which they said didn't have to be admissible. But
some was addressing the propriety of counsel's behaviour in pleading a case which damaged someone's reputation.
Yes.
And if all the evidence which allowed counsel to plead the writ was inadmissible, that could not meet your test that on the balance of probabilities the claim was likely to succeed. On the balance of probabilities the claim was likely to fail, but nonetheless it was perfectly proper to plead it and then gather the evidence.
But it's a matter of timing. It's a matter of timing. If the material is not admissible at that stage, but it is available, you can plead it. And then you, after you've pleaded the action, you have rights of discovery and so on and so forth.
Yes.
Can I just perhaps, your point about the Law Commission's splendid proposals not being pursued, I see that Professor Burrows in his article at MS 3459 tells us what happened, which is quite interesting. They were all set, and then a point came up under the Equal Pay Act, which they were able to, he says, I and my successor, Professor Hugh Beale, had no difficulty in advising on it. But by then the parliamentary momentum had been lost, and the bill was then dropped.
And the parliamentary majority was lost as well, because the election came very shortly after.
Yes, but I mean, unfortunately, this is the fate, as some of us know, of some Law Commission work. I mean, I'm not sure where that leaves us. We have the lordships in DMG, sort of, or Claimants, saying, well, if there are problems, this is a matter for the Law Commission. The Law Commission then faithfully go and look at it and, with the support of government, and produce a result which you kindly say is very sensible. But then, for whatever reason, the government drops it. I mean, one view is, well, then, too bad. It's not, the courts can't do anything to help. The other is that in those circumstances, the courts have got to step into the gap and try and revisit the situation. I'm not sure which the right answer is.
The answer to that is in the correct application of the practice statement. Of course, the points your lordship are making are very valid points. But then you have to say you are being invited to depart from two decisions, from Kleinwort-Benson and from DMG, in circumstances where legislation, Section 320, was introduced, no longer applies to taxation, that may have been badly introduced, which meant that a lot of claims got through. But it can't be the role of the court, I would submit, to say, well, we've got to help the revenue out because they botched up the introduction of 320.
It's not the revenue we're helping out, it's the law. I mean, it may help out the revenue, obviously.
Well,
what we're trying to get the law, and whatever the effect on this case is, we're trying to get the law into a sensible state. Isn't that right?
Well, you might regard the law as being in a sensible state. If your lordships were to accede to my, agree with my submissions, the law is in a perfectly sensible state.
No, I understand that.
Yeah. And I'd say that we are dealing here with a case of tax. We are dealing with a situation where the DMG decision and the extended limitation period has led to legislation, has led to the Littlewoods decision, has influenced the decision in Prudential. And therefore, it's inappropriate in this case for your lordships to do more than say that there are dilemmas, quandaries, difficulties, and this really ought to be sorted out by the Law Commission. And that the Law Commission report, I don't mean this in any disparaging way at all, it's a terrific document, and it should be resurrected and enacted. And a statement like that coming from 7 of your lordships, with a stable government, if that's the right word, at least a government with a stable majority, might be a better way of describing it, it's got plenty of time to enact it. It's not like the situation where 2009 in particular, the government was obviously in great difficulties, hence the election in 2010. Maybe that is the right course. But a better course, certainly a fairer course so far as the claimants in this case are concerned, a far fairer course than saying, well, we think that it wasn't, had they known in when DMG was decided or Kleinwort-Benson was decided that the Law Commission report was not, the law wasn't going to be changed despite there's a 300-page report, it's not going to be enacted. And had we known that attempts to deal with the taxation consequences were going to fail for a period of time because they're going to be improperly introduced as a matter of European law, had all that been known, then maybe the courts in DMG might have said something different. I respectfully submit that is not the right approach.
Well, speaking for myself, I don't think the problem is really to do with the non-implementation of the Law Commission report. The problem, as I see it at the moment, is that having decided to expand the scope of recovery on a restitutionary basis to encompass errors of law, mistakes of law, payments made under a mistake of law. The House of Lords then applied Section 32(1)(c) on the basis of a literal interpretation that the word mistake is capable of encompassing mistakes whether of fact or of law. They took the view that the mistake would not be discoverable in a case of a kind they had before them until there had been a final decision by a court of final jurisdiction. They recognized that that literal interpretation undid the purpose of limitation, which is why they regarded parliamentary legislation as essential. But the true implication might be thought to be that if you accept their reasoning, they should not have given Section 32(1)(c) a literal interpretation. If you gave it a purposive interpretation, you would then not be approaching the matter in the way they did. One possibility is you might say that mistake is restricted to mistakes of fact. Another is that you might find some way of applying it to mistakes of law, which is a proper application of the statute and is consistent with the purpose of the statute. And I think the Revenue are putting forward the Sefton approach as such an approach.
May I take issue with respect, my Lord, the word undid? I wouldn't say that the decision undid the purpose of the Limitation Act. It had an effect, but I've given an illustration, a fanciful illustration, an amusing one perhaps with the painting. Same problems arise in mistakes of fact.
If the limitation period doesn't begin to run until after there has been a final decision by a court of ultimate jurisdiction, that's incompatible with the basic purpose of limitation, which is to set a time limit for the commencement of proceedings.
That I understand, but that's why I'm not saying as a matter of principle it should be the final determination of the ultimate court. It can be much earlier. As it happens on the facts of this case, it can't be earlier, because there was nothing until we get to FII which really indicated to the that a mistake had been made. Possibly the Herx decision. I have to acknowledge, possibly. You might say, where there's a thunderclap, that's a wake-up call.
And the trouble I'm having with that at the moment is simply finding a criterion which is defensible for drawing the line somewhere. I mean, one could find ECJ judgments in the 1990s saying that national tax regimes couldn't operate in a discriminatory manner unless, I mean, there were qualifications, but that was the general thrust of decisions from the mid-1990s. And the subsequent case law is simply the application of that general principle in a number of specific contexts.
Well, the expansion of that, a great expansion of that principle. Certainly, as I say, I don't labour the point, but we all know Lord Walker's description as a thunderbolt, and it was a thunderbolt, a thunderclap. And that was, it made a loud noise and certainly alerted people to possibilities. But of course, I'm not disputing what your Lordship is saying. It's a very difficult task you have, but I'm concerned with the claimants in this case and the fairness to them in this case, and when they could have been alerted, and it would be grossly unfair to say that everything that was, the decision that was made in Kleinwort Benson, the decision that was made in DMG should just be swept aside and all their claims knocked out because Parliament didn't enact what everyone expected it to enact. Nothing unprincipled in the conclusion of the Law Commission. So taking your Lordship's point, they as we saw yesterday, the Law Commission approach was to say that the mistake of law should be treated as one of the facts, and only when that fact was reasonably discoverable should time begin to run, and that time should be 3 years. So that was a very considered view of the Law Commission. It's differing from the approach of your Lordship, which is saying, well, there's sort of an inconsistency because the law is always there, and this wouldn't allow limitation to run properly. It wouldn't allow it to run properly, and that's the approach I'm adopting here. Treat the mistake of law as if it were a fact, when that fact is discoverable. And here it's discoverable, we say, with FIR, but it might argue with Herx. Then time begins to run. Should that time be 6 years? Should it be 3 years? Should there be a long stop? Of course there should be a long stop. Subject, in case of personal injuries, to discretion to remove the long stop, because it might be grossly unfair because the disease may not become apparent for many, many years. And as I'm not sure I can really do more. I mean, if I was sitting there, obviously, I would be scratching my head and just wondering what is the right criteria.
But your test of prima facie, that on the balance of probabilities, a claim is likely to succeed. If we move away from taxation to an area of law where the boundaries can move, the realm of negligence. If we take the example of Anne's and London Merton Borough Council, then it is possible that after Anne's, local authorities paid out damages by agreement based on the Anne's judgment. And then several years, about 8, 9 years later, the House of Lords in Murphy says Anne's was wrong. Now, well, I don't want to get into the detail, I just want to look at it as a general point. If the test is on the balance of probabilities, a claim based on mistake of law of having paid out that money was likely to succeed, then it's very hard to see how that could occur until Murphy, the House of Lords in Murphy, reversed hands.
Well, one has the other defences, so change of position and so on, which was available as a matter of principle in the present case, but was not established as a fact.
It's just that
The
thing is we're having to deal with. I mean, obviously this thing has been focused on the taxation issue, and that is what's developed the law in this area. But we're ultimately interpreting Section 32, and we'd have to apply it to the law of negligence, and shifting boundaries there as well.
But there it would depend if there was personal injuries or latent defects. We have the provisions in Section 14 and 14A, and which explicitly require attributability to be taken as one of the facts, and attributability just means there's a possibility. So in those cases, the Limitation Act would not have any unfortunate
I think 14A is sufficient knowledge for bringing an action for damages. I think that's the test. In 14A.
Yes, but 14A uses the word attributable. If you actually see it, it's a very clumsily expressed. I hope none of your lordships had any hand in the expression of it, but I mean, it's worth looking at. It says the same as 14, but it says it in a much more clumsy way. It seems to me, it's an Authorities 1. At page 32, tab 6? Definition of date of, section 14 is at page 34.
Thank you.
Date of knowledge. For the purposes of 11 and 12. 11 is special time limit for actions in respect of personal injuries. There's a 3-year time limit from the date on which the cause of action accrued or the date of knowledge of later of the person injured. And then you have subsection 1, in sections 11 and 12 of this Act, references to a person's date of knowledge, references the date on which he first had knowledge of the following facts. 1, that the injury was in question was significant. B, that the injury was attributable in whole or in part to the act or omission which is alleged to constitute negligence. C, the identity of the defendant. And D, this is dealing with vicarious liability. And then at the end, a knowledge that any acts or omissions did or did not as a matter of law involve negligence, nuisance or breach of duty is irrelevant. So that was dealing with the injustice that was referred to in one of the cases. But the attributable is what was given the meaning. There's a possibility. So that's why there's no real problem there. If you turn over the page, you have 14A. Not quite sure why it's in this format, but this is 14A. Special time limit for negligence actions where the facts relevant to cause of action are not known at the date of accrual. And you'll see at the foot of manuscript memory stick page 36, textual amendments, sections 14A and 14B inserted with Saving by Latent Damage Act 1986. And it says the same thing. Special time limit. 1, this section applies to any action for damages for negligence other than one to which section 11 of this Act applies, that's dealing with personal injuries, where the starting date for reckoning the period of limitation under section 4B below falls after the date in which the cause of action accrued. 2, section 2 of this Act shan't apply to an action to which this section applies. 3, an action to which this section applies shall not be brought after the expiration of the period applicable in accordance with subsection 4. 4, that period is either 6 years from the date on which the cause of action accrued, or B, 3 years from the starting date as defined in subsection 5 below, if that period expires later than the period mentioned in paragraph A above. And then 5, for the purposes of this section, the starting date for reckoning the period of limitation under subsection 4B above is the earliest date in which the plaintiff or any person in whom the cause of action was vested before him first had both the knowledge required for bringing an action for damages in respect of the relevant damage and a right to bring such action. 6, in subsection 5 above, the knowledge required for bringing an action for damages in respect of the relevant damage means knowledge both A, of the material facts about the damage in respect to which damages are claimed, B, of the other facts relevant to the current action mentioned in subsection 8 below. 7, for the purposes of subsection 6A above, the material facts about the damage are such facts about the damage as would lead a reasonable person who had suffered such damage to consider it sufficiently serious to justify his instituting proceedings for damages against a defendant who didn't dispute liability and was able to satisfy a judgment. The other facts, in 8, the other facts referred to in subsection 6B above are A, that the damage was attributable in whole or in part to the act or omission which is alleged to constitute negligence. So it's the same test, as I say, expressed in an extraordinary waterfall of provisions. You have to go on and on and on until you actually get to them. But it's just saying the same as 14. The identity of the defendant, and C, dealing with vicarious liability. And then 9, knowledge that any acts or omissions did or did not as a matter of law involve negligence is irrelevant for the purposes of subsection 5 above. 10, for the purposes of this section, a person's knowledge includes knowledge which he might reasonably have been expected to acquire, A, from facts observable or ascertainable by him, or B, from facts ascertainable by him with the help of appropriate expert advice which is reasonable for him to seek.
So outside section 32, the approach both in relation to personal injuries, including that fatal accident, and also in relation to damage to property, latent damage in 14A, has been one which looks to the circumstances in which you can raise an action and using this attributability test.
Yes, that's the AB. That's the AB, Ministry of Defence.
Yes, but it's not confined to personal injuries. I mean, this
No, this is wider. This is wider. Yes, that's right.
Property damage, in fact,
Exactly.
anything other than section
Damage,
11.
Yes.
But that does put the House of Lords analysis of section 32 in a very, very different position from the rest of the Act.
Well, yes, but that's one way of expressing it. But what you can say is that section 32 is confined to cases of mistake, which are obviously not covered by more specific provisions, and more specific provisions would be 14A and 14. So most of the mischief that my Lord in the Chair has identified, or was reverting to, is dealt with by these sections. But it would be quite wrong to say, well, the approach taken in these sections and the approach of the courts to these sections with a specific meaning of attributability should then be imported into the quite different circumstances and very limited circumstances dealt with in section 32. Section 32 has its own code. Here you have different time limits. You have 3 years as opposed to 6 years. You have attributability and so on and so forth. They're very specific code.
Mr. Ensign, on your test of prima facie case, that on the balance of probabilities, if this case goes forward, it's likely to succeed. At various points in your submissions, you've referred to a range of uncertainties as to the likelihood of success, including the availability, potentially, of the defence of change of position. Is your test intended to cover everything that could arise in the...
No, it isn't.
Right.
It covers that we've got a good chance of success, but they're going to have a lot of defences.
So it's specifically on the, if you like, the main cause of action.
The main cause
of
action,
exactly.
I mean, there has been an astonishing number of defences raised here. As you look at the colour palette of the pleadings, I don't know whether you have a colour version of it. Quite extraordinary, really. It's sort of like a Farrow and Ball's colour chart. How many times have they been amended? 17. So there we are. So what I'm saying is, yes, there is a problem, and my Lord and the Chair has identified. Of course, there is a problem, but it is not a problem that sweeps across the whole board, negligence and personal injuries and all the rest of it. No. It's fairly restricted to the cases which have actually come before this court and are coming before this court. How many cases have there been after Kleinwort Benson and DMG. Not many. So the floodgates may be open, but there's no flood behind the gates. My respectful submission, this court should adhere to what was said in Kleinwort Benson and DMG, the expectation that any untoward consequences that arise from the postponement of the commencement of the limitation period should be dealt with by legislation. And in case there are many cases around, that legislation should be introduced fairly urgently and during the course of the current Parliament. In other words, I'm conscious of time, and I'm conscious of the fact that we have a very serious case on whether it's res judicata or whatever it is. And I'm wondering whether it would be appropriate for me to sit down, even if I haven't had the opportunity of answering every doubt that might be in some of your, all of your lordship's minds.
I wouldn't worry too much if you haven't resolved every doubt on your feet. We're going to be taking a long time to think about this after the hearing.
Well, Lord, and in our written case, I set out what I say is the right approach in accordance with the practice statement. I'm not sure I can put my finger on the particular paragraphs. I wrote it down somewhere, but I can't find it now. But I can just refer you to the case in court. Loss. Primary authorities, is it here? No, it isn't. No, it's not. It's tab 9.
This is the practice statement.
This is on the practice statement. Yes, and I'm just trying to find where we set it out. I had it yesterday. I think it's, yes, 3980, the practice statement in the light of the factors above, and
This is paragraph 82 of your...
82, which refers to the usual cases on that. Is a the statement of Lord Scarman at para 83 in the Kawaja case, the last clause, but also that judicial departure by the House from the precedent is the safe and appropriate way of remedying the injustice and developing the law. And I'd say, no, it isn't. It's an inappropriate way. In this case, the appropriate way is obvious. It was stated in Kleinwort Benson, stated in DMG, stated in the Law Commission report. That is the appropriate way. Because all you need is a sensible long stop. That's the end of the matter. If you don't have a long stop, you need loads of slip fielders. I mean, that's probably an even worse analogy than something I said before, but I mean, basically, this is what we're dealing with. In a few cases, you need a long stop. It's not for this court to change the whole learning on what a mistake of law is and how it fits into 32(1)(c), simply because there isn't a long stop there. The long stop needs to be put in place. What my Lord and the Chair is suggesting by saying it defeats the whole object, you're really taking the ball out of the bowler's hands rather than having a long stop to prevent any damage. We're just saying we're not allowed to bowl it at all. I think that's probably not the best analogy to end my submissions on, but I think I really should hand over to my learned friend. So unless I can assist Lordships further.
Thank you very much, Mr. Aronson. Yes, Mr. Margolin.
My Lords, I'd like to begin by outlining BAT's main objections to the appeal in terms of jurisdiction, res judicata and abuse, and in so doing, to address, I hope, my Lord Carnwath's question to my learned friend Mr. Aronson of yesterday afternoon. I'm also intending at an early stage of my submissions to do my best to answer my Lord Sales's query as to how it was in the circumstances that issue 28 came to be dealt with as between the Revenue and BAT in High Court 2. I should emphasise at the outset there's a substantial amount of material which is referred to in the annex to our written case and highlighted for the most part in the appendix, stretching back over many years of litigation on which the test claimants rely. Time and your Lordship's patience permitting, I will take you through, if I may, some of it, but I should emphasise that we maintain our reliance on all of that material in support of our position on jurisdiction, res judicata and abuse. I should also emphasise that that material is intended to give an unspun account of what's happened relevantly in the litigation to date, and it's significant in my submission that although there may be differences of interpretation as regards some of those documents, as emerged from Mr. Ewett's submissions, there's no issue taken as to the accuracy of what that material shows in terms of a complete picture relevantly of what's happened to date. The main points which we say this material demonstrates in answer to my Lord Carnwath's question are these. First of all, DMG was the basis of the Revenue's case at the first liability stage of these proceedings, and the court's decisions in Supreme Court 1 and ECJ 3 were necessarily based as a matter of logic on the premises that DMG was correctly decided and that subject to any statutory curtailment that was effective, the claimants benefited from the extended limitation period under section 32(1)(c). There was an express concession that but for section 320 and section 107, the claimants did benefit from the extended limitation period. And as we'll see, Mr. Justice Henderson expressly decided that the claims went back as far as 1973. We say that those circumstances, including the concession made by the Revenue, give rise to a cause of action estoppel. Alternatively, what we say is that what the Revenue are now trying to do amounts to a serious abuse of process. But I should emphasise our primary case is that this is an instance of res judicata in the sense of cause of action estoppel. And I should say, and I think this may be a problem inherent in this area, one of the difficulties concerns terminology. In the passage from Zodiac, Virgin and Zodiac, that we looked at in Lord Sumption's speech, he described res judicata as a portmanteau term used to describe a number of different legal principles with different juridical origins. And similarly, Lord Keith in the Arnold case, which was the leading case before Virgin and Zodiac and was interpreted and built on in that case. Lord Keith described both cause of action estoppel and issue estoppel as branches of the law of res judicata. I'll come back to the principles in a moment, but that's our first headline point. All of this was in fact determined in the first stage of the proceedings, the liability stage, and that's the end of it. Secondly, when the case first came before a panel of 7 justices in this court on limitation issues in Supreme Court 1, the Revenue, through my learned friend Mr. Ewett, expressly disavowed any intention of challenging DMG. And we say that that gives rise either to a cause of action estoppel or an issue estoppel, or in the further alternative, the Revenue's attempt now to resile from that position constitutes a serious abuse.
Remind me, have we got somewhere timeline of all these various decisions?
In our further documents, additional documents, it's at tab 1. There's a chronology of all the relevant judicial decisions. That's additional MS page 3.
This is the Respondents' additional documents. Yes.
My Lord, the third headline point is this. In High Court 2, the court made an order, that's Mr. Justice Henderson's order of the 30th of January 2015, declaring Declaration 24B, which your Lordships have seen but we'll go back to, that it is common ground that on any view the BAT claimants started their mistake claims within the extended limitation period. As a result, all of the mistake claims of the BAT claimants dating back to 1973 are in time. The Revenue never sought to appeal that part of Mr. Justice Henderson's order to the Court of Appeal. There was an appeal on the other part of Declaration 24, which was the binary 01 or 06 issue, but there was no appeal in respect of the admitted position, common ground, that the BAT claimants were in time in respect of all of their claims being entitled to the benefit of the extended limitation period. We say that that is an insuperable jurisdictional bar, or alternatively gives rise to a cause of action estoppel. We heard from my learned friend Mr. Ewart, the Revenue's case now in relation to that is that Declaration 24B would have been incapable of being appealed and in any event only reflected an agreement between the test claimants and the Revenue from which the Revenue should be permitted to resile. It's my submission, as I'll go on to explain, that both of those propositions are wrong. Fourth point is this. Going back as far as 2014, the Revenue have made admissions in their current defence, which we've looked at briefly, but time permitting we'll go back to, in the agreed list of issues for High Court 2, the agreed statement of facts and issues for High Court 2, which was later reused in Court of Appeal 2, and in their oral submissions to the Court of Appeal in Court of Appeal 2, that BAT's claims were in time, that the extended limitation period applies, that the claim in respect of D5 tax as opposed to ACT succeeds in limitation terms, and that a date of constructed discovery prior to 2001 is inconceivable. All of those admissions plainly directly contradict the case which the Revenue are now seeking to make, and we say that they too give rise to a cause of action estoppel, or alternatively, again, the Revenue's attempt to resile from their previous position represents a serious abuse.
Can I just mention, Mr. Margolin, while it's in my mind, that we're going to have to be careful to make sure we're dealing with all the claimants, and you're referring us quite understandably to the BAT position, but we'll need to know what the position is in relation to the other claimants we're dealing with.
Of course, we recognise that in relation to some of these issues, they apply, we say, to BAT and to the other test claimants who are in a similar position. There may be a dispute about that, and that they may not necessarily apply to the, I think, 8 groups whose claims were brought after the 8th of March 2007. Then there's the point which I've touched on already in terms of admissions, that it looks as though the Revenue conceded the appeal on D5 tax. And then lastly, there's the sort of sweep-up argument that, of course, the points that the Revenue are now seeking to take are entirely new points which have never previously been taken. It's not just a question of them not having been taken in the courts below in the second quantification stage of the proceedings. They weren't raised either in the first liability stage, where issues of limitation came before this court. And my learned friend Mr. Aronson was taking your lordships through that yesterday, and where, as Lord Walker put it, the correct construction and scope of section 32(1)(c was an issue before the court. We say that the burden, therefore, is plainly on the revenue to satisfy your lordships that they should nonetheless be permitted to run these arguments. And we say they've simply failed to demonstrate any good grounds as to why they should be allowed to do so now. And of course, what we say is that the claimants, all of them, will be severely prejudiced if the revenue are now allowed to take these points. And it was recognising our entitlement to make those arguments that the grant of permission was expressly limited, which I'll come on to in a moment. But we say there's a strong element of abuse underlying all of this, but that our primary objections really relate to matters of cause of action estoppel, issue estoppel, and jurisdiction. So there's another preliminary matter I should deal with, which concerns the effect of the grant of permission. If one looks at the revenue's written case, and I think even more clearly their reply, one could be forgiven for forming the impression that their position is that the grant of permission is somehow a sort of panacea that cures all of these difficulties. We say there are two answers to that. The first is that the grant of permission here is expressly without prejudice to our entitlement to argue that even if your lordship is persuaded to depart from Kleinwort Benson, that shouldn't affect the outcome of the present case. So that's really, it's no answer to say, as the revenue seem to be saying, that the grant of permission negates all of those difficulties. The second point, my lords, is this. Even without an express qualification of that sort, the grant of permission doesn't prevent a respondent from raising arguments that point to new points or are raised judicata. And that much is clear on authority, including Malarkey and Broad. It's been referred to. I'm not sure we need to go into it now, because whichever of those approaches is taken, the practical effect comes to the same thing. There is also...
we need to go there because you have an express reservation in the permission.
Precisely, my lord. There's also a question, I should say, as to precisely what it is that the revenue have permission to argue. I'll come back to that at the end, but as your lordships may have seen from the A3 coloured diagram, which is at tab 3 of our additional bundles, we are here seeking to deal with a moving target, which strikingly is involved a new case being made on Monday of this week, the day before a hearing in litigation, which has been ongoing for 16 and a half years, but which also features unusually my learned friend Mr. Hewitt being, if I may say so, rather coy in answer to my Lord Carnwath's question as to what his preferred case is. We say that exactly what it is that the revenue are permitted to argue is something which your lordships ought to consider carefully. I'll come back to it, time permitting, at the end. So, dealing with my Lord Carnwath's question as to what we're dealing with here in terms of res judicata or something aligned, perhaps something different, Virgin and Zodiac is cited by the revenue for Lord Sumption's explanation of what's meant by the portmanteau term of res judicata. I think it's at MS 789, the relevant paragraph. It's in Authorities 2, tab 23. So it's at C on MS 789. The passage begins, the reference to res judicata being a portmanteau term. The label tends to distract attention from the contents of the bottle, he says. And then there are 5 principles that he outlines. The first is that once a cause of action has been held to exist or not to exist, that outcome may not be challenged by either party in subsequent proceedings. This is cause of action estoppel. It is properly described as a form of estoppel precluding a party from challenging the same cause of action in subsequent proceedings. That, we say, is plainly engaged here. Secondly, there's the principle which is not easily described as a species of estoppel, that where the claimant succeeded in the first action, doesn't challenge the outcome, he can't bring a second action. We needn't concern ourselves with that or with the third aspect, which is merger. But then at F, he says, fourth, there's the principle that even where the cause of action is not the same in the later action as it was in the earlier one, some issue which is necessarily common to both was decided on the earlier occasion and is binding on the parties. Issue estoppel was the expression devised to describe this principle by Justice Higgins in Hoysted and adopted by Lord Justice Diplock in Tode and Tode. Fifth, there's the principle first formulated by Vice-Chancellor Wigram in Henderson and Henderson, which precludes a party from raising in subsequent proceedings matters which were not but could and should have been raised in the earlier ones. And finally, there's the more general procedural rule against abusive proceedings, which may be regarded as the policy underlying all of the above principles, with the possible exception of the doctrine of merger. Over the page, MS 790, at C to D, cites the very well-known passage from the judgment of Vice-Chancellor Wigram in Henderson and Henderson. And then, beginning at paragraph 20 on MS 791, he discusses the Arnold case, and at C and following, he refers to Lord Keith's having begun his analysis by restating the classic distinction between cause of action estoppel and issue estoppel. Your lordships have seen that already, but that is at the very heart of all of this. And there was then a discussion concerning the circumstances in which there were exceptions to the principles of cause of action estoppel and issue estoppel. There's a treatment in detail on MS 792 of Henderson and Henderson, the distinction there being between points which had been decided, in respect of which there was an absolute bar by way of cause of action estoppel, and points that hadn't been decided, wherein in certain narrow circumstances there may be exceptions to the application of the principle. And so one sees at D and E the relevant difference between the two was that in the case of cause of action estoppel, it was in principle possible to challenge the previous decisions to the existence or non-existence of the cause of action by taking a new point which could not reasonably have been taken on the earlier occasion. Whereas in the case of issue estoppel, it was in principle possible to challenge the previous decision on the relevant issue, not just by taking a new point which couldn't reasonably have been taken on the earlier occasion, but to re-argue in materially altered circumstances an old point which has previously been rejected. And then one gets, importantly for our purposes, my lords, paragraph 22, Arnold is accordingly authority for the following propositions. 1, cause of action estoppel is absolute in relation to all points which had to be and were decided in order to establish the existence or non-existence of a cause of action. 2, cause of action estoppel also bars the raising in subsequent proceedings of points essential to the existence or non-existence of a cause of action, which were not decided because they were not raised in the earlier proceedings, if they could with reasonable diligence and should in all the circumstances have been raised. 3, except in special circumstances where this would cause injustice, issue estoppel bars the raising in subsequent proceedings of points which 1, were not raised in the earlier proceedings, or 2, were raised but unsuccessfully. If the relevant point was not raised, the bar will usually be absolute if it could, with reasonable diligence, and should in all the circumstances have been raised. And then at paragraphs 23 and 24, going on to 25, he deals with the submission that recent case law had recharacterized the principle in Henderson and Henderson so as to treat it as being concerned with abuse of process and to take it out of the domain of res judicata altogether. He rejected that and talked about these being overlapping principles, distinct although overlapping principles, he says, towards the bottom of 794, with the common underlying purpose of limiting abusive and duplicative litigation. So that provides the most recent authoritative exposition of the principles which are in play, building on what was said in Arnold. And we have provided, I think overnight or this morning, a further bundle of supplemental authorities to deal with the points emerging from Mr. Hewitt's submissions, but also to assist me in dealing with my Lord Carnworth's question to Mr. Aronson yesterday afternoon. There's an important point. Perhaps I should wait to see whether your lordships can find the...
Is this the further supplementary authorities number 2?
Yes, it is, my lord. I'm very grateful. There are further supplementary number 2 MS page numbers as well. Arnold is at tab 1, beginning at MS page number 3. This was an issue estoppel case.
Hang on just a second. We've got,
Forgive me, my lord.
I see, we've got 3 supplementary authorities bundles.
This one is labelled Respondents Further Supplementary Authorities number 2.
I've got it.
4 tabs.
Thank you.
So this was an issue estoppel case where there had been intervening judicial decisions, including 2 in the Court of Appeal, between the date of Mr. Justice Walton's judgment and the next rent review where similar issues arose. It wasn't a cause of action estoppel case because it was strictly a different cause of action. But there was a common issue, hence it was analysed in terms of issue estoppel, and it dealt with the scope of the exception to issue estoppel where further material became available which was relevant to the correct determination of a point involved in the earlier proceedings, which could not, by reasonable diligence, have been brought forward in those proceedings. But I refer to it primarily for what is said at its internal page 104. Forgive me. It's further MS 14.
14?
At F. So this is beginning at D. One of the paragraphs that was cited by Lord Sumption in Virgin and Zodiac, but there followed some an ellipsis, and one of the propositions that follows in the original speech of Lord Keith in Arnold is at F. Cause of action estoppel extends also to points which might have been but were not raised and decided in the earlier proceedings for the purpose of establishing or negativing the existence of a cause of action.
Can I just, before we get too deeply into the detail, just ask you about a difficulty I'm running into. My understanding has always been, but correct me if I'm wrong, that limitation never goes to the cause of action. It goes to whether you have a defence. And that has importance in various contexts. In particular, it has to be pleaded. How, therefore, does a big argument which we're having about limitation give rise to cause of action estoppel? If the late raising of a limitation point might mean you lose, but it doesn't mean to say you didn't have a cause of action.
Well, what we say, my lord, is if one looks at the admissions and so forth that were made in the first liability stage of the proceedings, that there is an admission, a direct admission, that we have a cause of action.
Well, I understand that, but the limitation points now being taken are not aimed at your cause of action. They're aimed to establish a defence. I know that sounds a bit odd in the 21st century, but that is how it's always been understood.
Well, my lord, even if that's the case, what we would say if one looks, as I've said, our alternative position on this in terms of abuse, there could not be a clearer case of abuse than what we have here for the reasons which.
But I'm just responding to your starting by saying our main case is cause of action estoppel. And I'm just wondering whether we're in the right opera.
My lord, can I come back to that? And I recognise it's an important point, but given the amount of material which goes both to that issue and to the question of abuse, and an important point though it is, I'm concerned that I might get slightly sidetracked.
Can I also raise a preliminary point, which your answer may be the same? We're looking at the principles you've taken us to so far are to do with situations where there are subsequent proceedings and a matter either was dealt with or ought to have been dealt with in earlier proceedings. In this case, we only have one set of proceedings, which have been broken up into stages for case management purposes. And I don't know if you're going to address us at some stage on how the principles you're going to take us to apply to that situation.
My lord, yes. I can answer that now. They apply a fortiori, and that's the Fidelitas and Export Club decision.
Just before you come to that, and relevant to my Lord Briggs, I mean, there must be authorities which deal with the sort of these principles in the context of defence. I mean, Lord Sumption's dealing with them in the context of a claim, but there must surely be similar principles which preclude you from raising defence points.
We would say they're identical principles, and if one looks at some of the authorities, one sees references to
Anyway,
matters
come
which
to
are
that, but I don't
traversed
assume.
or not traversed.
And I would be sorry if it was all pushed under the umbrella of abuse, if there actually is clear authority on the point. We'll come back to Fidelitas.
So you're at Arnold at page 104F,
Well, maybe.
I think.
My lord, yes.
Yes.
And
You're going to come back to Fidelitas, are you?
well, I was going to go there, but I was
Okay.
just checking to see whether there's anything else of value to be garnered from Arnold.
Well, just before we leave Arnold, I mean, you quoted the sentence that cause of action extends to points that could have been raised. And Lord Keith goes on immediately to refer to Henderson and Henderson. So is he, in that presentation, including Henderson and Henderson abuse within cause of action estoppel?
Can I answer that this way? Henderson and Henderson extends the scope both of cause of action estoppel and of issue estoppel. And for those purposes, it is part of the law of res judicata. It also provides separate grounds where neither cause of action estoppel nor issue estoppel would be engaged. For example, Johnson and Gore Wood, where you haven't got an identity of parties, and a failure to take points in earlier proceedings when they should have been taken, often referred to as Henderson and Henderson, exists as a distinct concept from cause of action estoppel and issue estoppel as a form of abuse. In relation to Fidelitas, it's at Authorities 5, tab 72.
Fidelitas. Could you have the reference again, please?
It's MS 2004.
Okay.
2004. And just to orientate ourselves, at 2005, in the head note beginning just above B, there's a reference to the fact that the principal issues before an umpire were whether the ship was fit for the carriage of grain, whether by reason of assessor clause the owners ought to have recovered demurrage by insisting on their lien and not having done so couldn't recover against the charterers, and third, whether as the owners contended the charterers by a payment had waived the assessor clause. That went to the judge, who decided that the claim for demurrage was excluded by the assessor clause, and that decision was affirmed by the Court of Appeal, and the House of Lords refused leave. When the award went back to the umpire, the owners sought again to raise the point about waiver of the assessor clause. Mr. Justice McCatter held that the owners could raise the point, but the appeal was allowed. If the owners had desired to raise the point of waiver in the assessor clause, they should have had the relevant facts stated and a specific question asked about it in the relevant case. So that's the context. And if one goes forward, my lords, to page 2016, one sees, beginning at B, Lord Justice Diplock saying, in the case of litigation, the fact that a suit may involve a number of different issues is recognised by the rules of the Supreme Court, which contain provision enabling one or more questions, whether of fact or law, in an action to be tried before others. Where the issue separately determined is not decisive of the suit, the judgment upon that issue is an interlocutory judgment and the suit continues, yet I take it to be too clear to need citation of authority that the parties to the suit are bound by the determination of the issue. They cannot subsequently in the same suit advance argument or adduce further evidence directed to showing that the issue was wrongly determined. Their only remedies by way of appeal, and where appropriate, an application to the appellate court to adduce further evidence. And then at E and F, a statement of that principle, but an example of a specific application, the general rule of public policy, nemo debit bis vexare pro una et eadem causa. The determination of the issue gives rise to an issue estoppel. It operates in subsequent suits between the same parties in which the same issue arises. A fortiori, it operates in any subsequent proceedings in the same suit in which the issue has been determined. Your lordships were taken by my learned friend Mr. Ewart to a case called, a relatively recent case called Musaji. We can go back to it if necessary. But both Lady Justice Arden and Lord Justice Dyson clearly stated in that case that the abuse doctrine, for want of a better expression, was available in the context of one set of proceedings. Obviously, it depended on the circumstances, and the circumstances of that case were quite extreme because there was only really one issue ever dealt with in the first round of the litigation. And the argument that was raised was a double-edged sword because, if true, it meant that neither party would be able to put forward its case in the second stage of the proceedings. That's emphatically not where we are here. There is a further point which is addressed by the material in our further supplementary authorities, which relates to the significance of admissions as opposed to determinations. And if one goes to tab 3, that's MS 57, further supplementary number 257. Finds the case of Hoysted. So this is again,
where is this? Sorry,
this is in our further supplementary authorities number 2,
yeah.
with 4 tabs.
Okay.
My lords at MS 65, towards the bottom of the page, the last 2 paragraphs, there was a determination that there was an estoppel by judgment, and the court said it's necessary to examine carefully the argument presented against such estoppel. It amounts to this, that in the former case it's not a matter of decision that the appellants were joint owners, but was matter of admission. And if one goes forward to MS 67, in the final paragraph, it said that very numerous authorities were referred to, but it was settled that the admission of a fact fundamental to the decision arrived at can't be withdrawn, and fresh litigation started with a view of obtaining another judgment upon a different assumption of fact. That applied also to erroneous assumptions as to the legal quality of facts. Parties are not permitted to begin fresh litigations because of new views they may entertain of the law of the case, or new versions which they present as what should be a proper apprehension by the court of the legal result, either of the construction of documents or the weight of certain circumstances, and a reiteration of the general principles concerning the undesirability of relitigation. And I mention that, and as an analogous point has been made by reference to Johnson and Gore Wood, into the support of the proposition that admissions in this area of the law, we say, are to be treated as equivalent to determinations. And the reason for that, in my respect for submission, is obvious. The same policy drivers about avoiding relitigation, no one should be vexed twice in the same cause and so forth, apply with at least equal force where there have been admissions rather than determinations.
But it may depend on the circumstance of the omission. I mean, there may be circumstances where it is quite proper for someone having omitted something to withdraw it. It depends on what has happened in the interim.
Yes,
it's different from determination.
Yeah, in this case, there had been an admission in previous litigation on which the decision had been based.
As we'll see when we look at what happened in the first liability stage of the proceedings, we say that something very much along those lines has happened here. Johnson and Gore Wood, we say, is authority for a similar proposition in relation to Henderson and Henderson more generally, and it's at Authorities 1, tab 12. MS 350, my lords. Lord Bingham says at H, the second subsidiary argument was that the rule in Henderson and Henderson didn't apply to Mr. Johnson since the first action against GW had culminated in a compromise and not a judgment. This argument also was rightly rejected. An important purpose of the rule is to protect a defendant against the harassment necessarily involved in repeated actions concerning the same subject matter. A second action is not the less harassing because the defendant has been driven or thought it prudent to settle the first. Often, indeed, that outcome would make a second action the more harassing. My lords, if one looks at MS 377, Lord Millett says below B, dealing with the principle of Henderson abuse, in one respect the principle goes further than the strict doctrine of res judicata or the formulation adopted by the Vice-Chancellor. For I agree it's capable of applying even where the first action concluded in a settlement. Here it's necessary to protect the integrity of the settlement and to prevent the defendant from being misled into believing that he was achieving a complete settlement of the matter in dispute when an unsuspected part remained outstanding. So we say that in the context of abuse as well, the fact that something is the subject of an admission or a compromise doesn't in any way detract from the impact of the fact that that issue has been resolved in earlier litigation.
A fair bit of quite recent authority under the CPR, at any rate, about the circumstances in which permission should be given to withdraw an admission. I don't know if you're going to take us to any of that.
My Lord, we looked during the learn from Mr. Hewitt's submissions at one of those cases, Notting Hill Finance, which talks about new points and so forth. Perhaps that would be a good place for us to go after the short adjournment, because I was proposing to say something about those.
And I'm not encouraging, I just a bit in the back of my mind that it's there.
That was part of the roadmap, my Lord.
Yes. Very well then.
Can I just clarify?
Well, yes.
Do we get Mr. Aronson again after you, or I'm not saying we should. I just want to be clear what the programme is.
Only if you don't get Mr. Hewitt.
That's right. So this is the last part of
This is the last hurrah.
Respondent submission. Thank you. Sorry.
Yes, and you're on track to finish in another hour, are you?
Well, it'll be a struggle, my Lord, but obviously I will
Yes.
respect the
Yes.
discipline that
Very well.